shall be heard. I said Commonwealth of Massachusetts, this court is now open.
Good morning, and welcome both of you to the Appeals Court session for March 7th, 2024. I don't really think with just only the two of you here, I really need to go through much. Hopefully the others will show up. So I'll just call the first case, which is Commonwealth versus Gonzalez, 2023P851. And this is a Commonwealth appeal. And then after this, you'll go and sit in the other chair.
Thank you, Your Honor. Good morning. May it please the Court. Stephen Nato, Assistant District Attorney for the Bristol District, on behalf of the Commonwealth. Our position today, and of course what brings the appeal here, is our contention that the motion judge erred in finding that the inevitable discovery doctrine did not save the video evidence and the motor vehicle recovered in this case. I think
so. I just wanted to clarify. So the two things that are suppressed are the footage, the video footage, and then the car and whatever was in it.
Yes. Yes.
Okay. The fact that he drove and that what's the relevance to the fact that he drove off and that his girlfriend picked him up? Is that inculpatory somehow?
Well, there are certain documents, and I believe some trace GSR found in the defendant's vehicle that do help tie. The case is viable even with this evidence suppressed, but it does help sort of tie off some of those knots in the identification of the defendant in this case. But of course, I think I have to begin by acknowledging the constitutional violation in this case, which is a frustrating error. There's sort of no way around it. Certainly speaking with the prosecutor and indeed the trooper who requested the CSLI, it's a frustrating lapse of judgment from someone. This is an out of character.
Right. If they'd asked for like the 2 hours after the shooting, the 6 hours after the shooting, we wouldn't be here.
Right. So, and to the extent, obviously, we have no explanation really, or certainly a satisfactory explanation for why this was a 72-hour request as opposed to what was clearly indicated as of 2015 by the SJC.
On the affidavit, or on the application, it said they were looking for the gun there. So maybe that's why they'd want 3 days, so they could maybe follow the defendant and get the gun.
Right, right. But nonetheless, to request that was clear a warrant was necessary.
But then Trooper Morissette's emails to the other police officer, his August 13th email, talks about, also reviewed his estimated location data, 2150 at the scene of the shooting, 2156, 2122, two possible areas off Dartmouth Street, south of Cove Road. So that's like a half an hour, 2156 to 2212.
Right.
So should we be concerned about whether or not the defendant is prejudiced? If they ask for 3 days, but they only tell the other police about half an hour, what do we do with that?
I think that would go perhaps to the severity of the constitutional violation in this case, that we only retrieved ultimately a small window of time, and ultimately it only gave us a general area of where Detective Wadman was already searching, essentially. And I would point to the judge's findings. I think it's on page 12 of his decision. Obviously, that's in the addendum, but it's on 175 of the appendix, where he says that Detective Wadman was on the right path by the time he got to that sort of stalling point at Dartmouth Gas, where he, it's well described, this process of chasing video. It's sort of a routine, like fundamental of police investigations, certainly in a murder case, that would always be part of it. It involves not just finding the suspect vehicle and chasing it, as it were, along the path of the video, but excluding dead ends. And to the extent there's ambiguity in the video, where did it not go? And that's sort of evident in Wadman's progress.
So as a matter of fact, Waldman was assisted by the data from Morissette.
Yes, and it's not clear how, I don't think Trooper Morissette was there with him every step of the way on chasing, but it's a collaborative investigation. Obviously, there's not just emails, but discussions. No man is an island in this kind of situation.
Well, does Prevet, what do we do with Prevet and the horizontal versus collective knowledge doctrine in this? Does that change anything? Does that encourage?
I don't think so, and I know I don't think this case turns on whether Wadman. I think we can assume that Wadman knew in some sense about the CSLI, but there's no indication that it accelerated him along his path or diverted him from the path he was already on. And I think that's what I really hang my hat on, that Detective Wadman was on the right path following this sort of classic method of chasing video.
So your inevitability argument, does that turn on, what do you, can you sort of pinpoint what that turns on? From looking at your brief, it looks like the certainty that this process of following the video, that's the certainty, that this process would have, is that what you're relying on? This process would have been followed in any event?
Yes, and I would suggest that in this case it did inevitably lead to it, because there's no indication that it was like, oh, well, we got the CSLI and now I know that this video that I'm looking at with my own eyes is accurate. I mean, he's been looking at the video with his own eyes and following it along the right path, and it is that exact same process which leads him to Dartmouth Gas, then down Cove Road onto St. John. And so I think certainly as to the video, there's no indication that the acquisition of the CSLI influenced that piece of it in any way. I think where it does become more complicated is the recovery of the vehicle itself, where the proper path and the improper path sort of converge at almost the same point. And there's obviously some evidence that Detective Wadman, couldn't get the St. John ring camera video immediately at that time, so it was either some discrepancy whether it was actually recovered at a later date or later on that day. I think the judge's finding is that it was ultimately recovered at a later date based on Detective Ray's testimony. But nonetheless, he had followed that path to St. John Street, and was certain to, try to recover that video because, again, may not be the same in every case, but this being a homicide investigation, with participation of the DA's office, looking forward to trial, this video, and as you can see, the sort of compilation for the court itself, provides very clear, for the most part, evidence of this suspect vehicle traveling on the path. There are a couple, as my sister points out, videos where it's less clear, perhaps. There's a partial view, but ultimately this path does lead sort of straight on to St. John Street, directly across from where the vehicle itself was recovered.
It would have taken longer, no doubt, right? He wouldn't have found the car as soon. Wouldn't have found the video soon, and then wouldn't have found the car as soon.
Some amount of time longer, and part of where it gets complicated is, could the recovery of the vehicle have sort of, taken the urgency off needing to recover that last ring camera video from 28 St. John Street, perhaps. And I note, I don't think this is cited in either of the briefs, but Nix versus Williams is, the Supreme Court case, 467 U.S. 431. And there...
but in Nix v. Williams, that's the Christian burial speech case where the police had already started the grid search of the area when the defendant disclosed the location of the victim's body.
Yes.
But the victim's body is presumably not going to move, unlike the car here. But also, once the police find the body, based on the defendant's statements, I presume they stop the grid search. Do we know whether here Wadman would have or did stop the video search once he learned that Foley found the car?
Well, I don't think he stopped the video search because essentially the video search had ended. It was just a question of recovering.
He stopped retrieving, did he stop retrieving videos once the car was found by Foley?
Well, no, because the Ring camera video itself was recovered
Right.
after the fact. But clearly he had sort of gotten to the doorway to the point of trying to, contact the homeowner by the time the vehicle is being discovered. So, and I just reference that because in Nix, they talk about, once they get the improper statement out of the defendant, it sort of takes the pressure off the search party to recover, but the search party inevitably would have discovered the body. And I know that in Massachusetts we have a more demanding test, but I just cite that as perhaps instructive on the issue.
How do you distinguish the Perrott, P-E-R-R-O-T case?
Is that the pocketbook case?
Yeah.
Yes. So that one, I think it was 10 days where this pocketbook is sort of missing in action. And although there's sort of general discussion about we are canvassing the area, there's not a defined path that necessarily the officers in that case are on. But here there is although it, and again, involves some false positives or a couple dead ends, but there is a clear path that begins before the CSLI is even requested that Stephen Wadman is following, and he follows the right path to Dartmouth Gas, which is essentially within the CSLI area, although they do sort of narrow it down to a few other areas, but he's basically sort of in that sphere of influence already, or at least once he recovers the Dartmouth Gas video, sees the suspect car driving straight into the center of that circle, basically. The CSLI only confirms, in a general sense, what he is able to observe in a very specific, concrete sense. And the timeline here also, 10 days, a purse that, you don't have a path exactly that you're following. There's less inevitability here, but here we're dealing with a couple days. Detective Wadman, even before it's requested, is pretty doggedly following this video evidence along the path and continues to do so in exactly the same way he did prior to the request. And so I urge the court, the test for inevitability is appropriately demanding, but should not be punishing. And I think it would be punishing in this case. The CSLI, I think the remedy is suppress that, but Detective Wadman's independent investigation, which has an independent investigative rationales urging him along, it should not operate to exclude that evidence.
Can you talk some about how do we look at severity, the severity prong in this case?
So, when I think the primary thing in severity would be the bad faith.
And there's a factual finding
Yes.
of no bad faith.
Yes, you found no bad faith, but notwithstanding that, there was a clear violation of the SJC's decision here. But I think that no bad faith finding sort of undermines the severity where there's, as I've sort of said, there's no indication that we're taking advantage of the improperly seized or acquired evidence, and that the evidence acquired by Stephen Wadman is sort of distinct, does not require any warrants in and of itself for him to require. So it's not like we're bootstrapping this improperly acquired CSLI to justify a further intrusion into the defendant's protected interests. All we get here is a sort of vague area that the police are already looking in, and the evidence recovered is unrelated to the CSLI.
If the purpose of the exclusionary rule is to deter police misconduct, wouldn't a good slap here be, useful in deterrence? Like, you really, no, you know, there's 6 hours, you know.
Yes, and as I've acknowledged, no real getting around
Yeah.
that. But I think, again, does the rationale of the exclusionary rule apply to Stephen Wadman's conduct, which, you know, is permissible, does not require a warrant, does not intrude on the defendant's constitutionally protected interest when there is a remedy that meets the violation, is proportional to the violation in this case, and that is the suppression of the CSLI and anything that flows more directly from it. Again, our position here is that this is separately admissible under inevitable discovery. If there are no further questions, leave it at that.
Thank you.
Thank you.
We'll hear from Attorney Grant. Good morning.
Good morning, Your Honors. May it please the Court, Ann Grant for JONOVAN Gonzalez. Your Honors, I think I'll try to pick up on some of the questions that were just asked of Attorney Nadeau. At the beginning, I believe Justice Grant was asking about the amount of CSLI that was requested and whether the use of only a 30-minute period impacted how bad it was, and I apologize if I'm mischaracterizing that. But I just want to point the Court to Estabrook, which squarely answers the question of whether the police or the prosecution's intent to use only a limited portion of time undermines the fact that they violated the bright line rule of getting more than the 6 hours they're allowed to get. And the answer to that is no. And they did, in fact, obtain 3 days' worth, 72 hours, 12 times the amount that they were allowed to obtain in this case, and had that in their possession. And the whole point is to not have it in their possession, the government, the police's possession, unless they get a warrant for it.
So what if the judge had said, I'm going to suppress all of the CSLI and any fruits thereof for a 6-hour period, 3 hours before the crime and 3 hours after? Wouldn't you have a very different argument?
If the judge had chosen to suppress the evidence that they obtained outside of the 6-hour
Correct.
period that they're allowed to get, that's what Estabrook answers. Because in that case, the police asked for 2 weeks, but they only intended to use a very short period of time. And the court said, too bad. What you obtain is what defines the constitutional violation, not what you intend to use. So you don't get to use it. So the fact that they obtained 3 days' worth, even if they only used a short period of time, Estabrook squarely answers that doesn't matter. And in this case, I think it's really important to note that the prosecution tells you that they hang their hat on the idea that Detective Wadman would have inevitably followed video surveillance to the same location. And the judge below simply did not find that. His specific finding is, it is unclear on this record whether Wadman would have similarly proceeded had investigators not received Morissette's email concerning the CSLI. And that's on page 37 of the addendum to his decision.
Isn't the judge confusing there the concept of inevitable discovery with independent source?
No, Your Honor. And the reason is because it's clear in that writing and in multiple other places in his decision that he's reciting the inevitable discovery doctrine. He understands what it requires, and in order for the Commonwealth to carry their burden of preponderance of the evidence, they have to show that this video and car would have been virtually certain to have been found, regardless of the constitutional violation. And there's ample evidence that that is not the case. And that's what I really want to point this court to. And it's important, and I think it's helpful to look at page 91 of the appendix, which shows the map in the case. And the reason I point to that is first to clarify for this court that the blue lines are not indicative of the car's path of travel. What matters here is the letters, which indicate where the video surveillance was obtained, and the key on the right side of this map that shows which video surveillance was obtained before the CSLI and what was obtained after. And if we follow this map, we see that in the location of H, that is where the crime occurs. The car then travels in the direction of B, which is west, and then south towards the intersection at Dartmouth and Rockdale, which is E and F. At that point, The police later learn that the car turns south towards J. J is Dartmouth Gas. But where does Detective Wadman next obtain video? This is E and F is where he leaves off before they get the CSLI. He next obtains video at G, which is east of the intersection where the car never traveled, and at a intersection off the map to the northeast of this entire area.
But he rules those out.
I'm sorry?
But by trying to obtain those by obtaining those videos prior to the CSLI, he rules those out as a possible direction of travel. So
He doesn't, Your Honor. In the email that Officer Morissette sent, it says that Detective Wadman obtained video at Bonnie and Revere, which is the intersection completely off this map, and that it showed a car that matched the suspect vehicle's description. And it is not until after the police get the CSLI that Detective Wadman returns to Dartmouth Gas, which is that intersection south where the car actually traveled.
But that's
and
the
went
one
in
where
those
he
directions.
went to Dartmouth Gas before the CSLI, but the manager wasn't working and was told to come back the next day.
Right, and that is where,
You want us to infer, or did the judge find that if Morissette hadn't sent the email about the CSLI, Wadman never would have gone back to Dartmouth Gas and the manager never would have called him to follow up?
well, so the manager told him that day when he went to go look at the video that it wouldn't be available till tomorrow. Wadman then doesn't return for 2 days, not until after the CSLI tells police, actually, this car went south. And that's when he returns. And what Judge Perino found is that in that set of circumstances, it was not inevitable, it was not virtually certain that Detective Wadman was going to figure out that, oops, I'm following the wrong car, off the map. I better go back there. He might have, but he might not have. And even probably doesn't satisfy this test in Massachusetts. The Hernandez case says this is a demanding test in this state, and it has to be virtually certain that the police would have gone there. And the evidence simply doesn't support that. So if I could, maybe I'll turn to the, unless there are any other questions about the reason.
Is there a preponderance standard in here somewhere?
The Commonwealth has to prove to a preponderance that the finding of the evidence was inevitable. That inevitability part, I'm with you, it's a little, it's a little weird, right? Because it's a lower standard than the actual test itself. But they still have to show that to a preponderance, it was virtually certain as a practical matter, the police would have gotten this evidence anyway. And there's just ample, and if I could, I'm sorry, Justice Grant. There's a couple statements that other police officers who make in their testimony that are pretty instructive here as well. Yes, you have Detective Wadman who is up there saying, I would have gone there no matter what. But you have Detective Ray who's leading the investigation who says probably the car turned south at Dartmouth Gas. And you have Detective Morissette, the one who obtains the CSLI, who says after that EF intersection, we started pulling video to see if we'd get lucky. That's his testimony. And he testifies that he is working directly with Detective Wadman. In that situation, Judge Perino could not bring himself to find that Detective Wadman was definitely going to go back to these locations and find this video in this car. And that is amply supported, that finding.
What do you do with your opposing counsel's argument that they would have kept looking, Wadman would have kept looking because it was video, and video is a better exhibit than CSLI. It's more precise, and it's something juries like to see and can understand more easily.
Sure. With all due respect to Attorney Nato, the CSLI pinpointed the exact location of the vehicle. The blue lines that are sent in Detective Morissette's email cross 10 streets, on one of which the car is found. And all
That's
of
not
these,
a pinpoint.
well, it's not the exact location, but it is certainly more accurate than following video a mile away, or even the video that the prosecution is acknowledging. If you look at the screenshots of these videos, they're not that clear, and they did not introduce all the video. So we don't know, that video is constructed with 20/20 hindsight after they found the car. That's when they paste it all together, present it to the judge, and the judge, even watching that video, says, still not inevitable. And his conclusion is amply supported. All you have to do is look at those and then realize, gosh, it is hard following surveillance video. If it's nighttime, this is a tan car, it appears to be different colors depending on the video, it's tough to follow. So you can see why with 20/20 hindsight, you can paint a much more clear picture. And the prosecution attempted to do that here and still failed to convince the motion judge. So I would ask that this court find, as Judge Perino did, that they just would not have inevitably found this car. They might have, but that doesn't get us over their burden. If your honors would like, I can move on to the severity prong. If there are no other questions on. Okay, so with respect to severity, I think it's important to look at other cases where the constitutional violation was not severe, and that was found by a court. And in those cases, and they're all cited on examples of cases where there's inevitable discovery are cited on page 17 to 18 of my brief. And you have, a series of cases where evidence that was illegally found in a car would have been legally located in a subsequent inventory search that was legal. Evidence obtained on somebody's body would have been found in a subsequent search that was legal. Evidence that's obtained from a search warrant would have been found in that same location if you just excise the unconstitutionally included information. These cases are completely different than what happened here, where the police have a bright line rule, a black letter law, where they have no discretion telling them exactly how much of somebody's CSLI they can obtain. And why did the court say that? Because CSLI is akin to 24/7 surveillance, and it follows people into their homes, into their places of worship, of business. It follows where they meet their friends, other people with whom they associate. It is a significant privacy violation to obtain more than the 6 hours that the SJC said they were allowed to get. And that is why it is so severe that they just did it anyway, with no explanation whatsoever.
So severity turns on the blatancy of the violation?
It turns on the significant privacy deprivation to the individual. We do not want to incentivize people or the police to go out and just it's so easy for them to get this information. They just fill out a form, send it to Verizon, send it to AT&T, and those companies will send them all the data. We don't want to incentivize people to abuse that power, the police to abuse that power. So it turns both on the privacy deprivation, the invasion to the defendant or any individual out there, because this could happen to anyone. And it also turns on, yes, you were told exactly how much you could get. You got more than that anyway, with no explanation. And we do not want to incentivize, I would ask this court not to incentivize carelessness or ignorance of the law, whatever explanation the police may have had for just simply defying that bright line rule that's laid out in Estabrook.
So are you saying that if suppression leaves the police or the Commonwealth's case in a worse position than if the violation had never happened, too bad, that's what Estabrook says?
Yes. I mean, in Estabrook, it tells you exactly how much you're allowed to get. In the inevitable discovery doctrine, one of the questions is the violation severe? And that question really comes after you decide, which I hope this court does not, that they would have inevitably found the evidence, okay? So if they wouldn't have, all of this stays out. If they would have, then the question is severity. Was it severe enough to suppress? And my contention is CSLI is an intimate picture of someone's life, described in detail in Augustine. Estabrook recognized that and said, we do not want to incentivize police to get more than the 6 hours we have allowed, and for those reasons, this is a severe constitutional violation. Whether the police had bad intent is simply irrelevant, and that is what the judge below found.
Is it like a 1-2 thing like that? First, the Commonwealth's got to prove A, and then they've got to prove B in terms of the severity? Or is there some sort of balancing? Like, if it's, maybe it's almost clear, but it's very severe, then you wouldn't do it. But if it's very clear and is there a balancing, or is it really a one, like?
It's a 1-2 because they have to prove that it would have been inevitably found. If they don't prove that, regardless of how minor the violation was, the evidence is still excluded. So once they get over that hurdle, which they definitely do not in this case, then the question is, okay, they would have found it anyway, but is it bad enough that we don't want to incentivize police to do this?
So is the question as whether it would have inevitably been found a question of fact on the credibility of Wadman, who said he would have kept going, or is it a mixed question of fact and law?
It's a question of fact, and that's where, pardon me, that's where what the Commonwealth is in essence asking this court to do is make a different weight and credibility finding than the judge below, because the judge heard contradictory evidence from the police. You had Detective Wadman saying, I would have done all this anyway. Yes, I got Morissette's email, but I didn't see it. I didn't know about it. I was talking with Trooper Bonnet, I was talking with Trooper Morissette and Detective Ray, but I never heard anybody mention CSLI. That's his testimony.
On the issue of whether Wadman would have kept going is what I'm concerned about. Wadman says he would have kept going.
Right.
What evidence was there contradictory to that? Did some other police officer testify? Oh no, I told Wadman to stop once we found the car.
The other officers testified that they were all aware of the CSLI and that they were working with Wadman. Wadman's claiming he doesn't know about it. And then we have circumstantial independent evidence that shows Wadman is going the wrong direction 2 times. And yet he's claiming on the stand, I would have inevitably gone back to this location, when that is 100% undermined by the question marks the other police who are running it and who have the CSLI are saying about the video surveillance, and by the circumstantial evidence in the case that the Commonwealth submitted. I mean, the email showing that they have identified the car in a completely wrong location came from them, and it's in the record, along with going to location G, which is also the wrong direction. So the point of saying that is, where you have contradictory testimony by the police, and the judge determines that Steve Wadman would not have gone there inevitably, it's not clear that he would have done that, he made a credibility determination that this court cannot disturb.
Okay. Good. Great. Well, thank you both. Really, really interesting case. Very well argued and briefed by both of you. So we'll take the cases submitted.
Thank you, Your Honor.
So a lot of people weren't here when we got started today. We're going to be hearing 5 cases today. We've heard 1 already. We traditionally take a break after 3. So this morning we'll be hearing the 2 criminal cases and the DCF case. We'll take a break around 11, and we'll come back at about 11:15 for the KLIGLER case and the Clark case. So just for your planning purposes. So the next case is Commonwealth versus Bonnet, 23P28.
Good morning. May it please the court. Sharon Sullivan Puccini on behalf of the defendant, Tavares Bonnet. Okay, so I'm going to get right into the first argument concerning the affidavit by Detective Barboza and nexus. What's enough for nexus? Our argument is here, there's not enough. And I cite to Andre Fields and the concurrence by Justice Henry, and she does a great appendix outlining all the cases on, what is enough. And her position, which we are arguing basically, is that Klagan is not enough. That's the threshold. That's 3 buys. And even with sufficient evidence, the additional evidence, we don't even have that here. So we're asking you not to lessen the threshold by
So, I mean, aren't there one-buy cases?
There's one-buy cases, but with those one-buys, which the Commonwealth does cite, Escalera, Hardy, with that one-buy, you have to have sufficient additional evidence. We don't even have that here. So let's look at what we have here. That the Commonwealth points to. So they say we have the 2 buys, but what's the extra information? The Commonwealth argues innocent details.
So the CI says, defendant is dealing drugs out of 229 North Street using a Mercedes. Twice, they do controlled buys where the defendant leaves 229 North Street, gets into the Mercedes, and goes to the location and does the sale. I mean, you mentioned that he doesn't go back, but
Correct.
doesn't that kind of show that he's getting the drugs from the house, putting them in the car, and going to the sale?
Klagen was considered by the SJC, and this court uses that case a lot. That was 3 controlled buys, and 2 from, 1 back, and that was considered a close case. Here we only have 2, but let's look at okay, so we have 2, but let's look at the additional evidence. And the Commonwealth says that the tip was corroborated by innocent details. So these are things that could easily be corroborated by anyone, right? Physical description of a black man in his 40s, that's bald. They did have a picture, and the CI said, yes, that's the person. What's important, though, in this case, this CI has not been determined to be reliable. In other cases, Tapia is one that the Commonwealth relies on. They talk about, there's a lot more there. In Tapia, they have a reliable CI, very important, which we don't have here. Utility bills in the defendant's name tying to that residence, okay? And also the phone used tying to that residence. We don't have that here. We have a vague affidavit with information not detailed enough, okay? You have, he also points to, I said the car is not, they looked at the registry for the car, the registry RMV records, not tied to the car, not tied to the house. Then he points to, okay, there was recent arrest for Brockton for possession of intent to distribute Class A. That was in April 12, 2019. And then he lists a bunch of arraignments. Again, they're arraignments, they're not convictions. And Commonwealth.
What do you do with the fact that there's 159 of them? Does that distinguish it all from Ponte?
Well, 159, no, because it's their arraignment. So what happens? There's nothing specific that he was even convicted of any of those things. What else? Okay, and the other thing is surveillance. They point to surveillance. So there was surveillance. It says several. I Googled what several means, and it's 2, and not many. 2 or not many is what Google said last night. So several is not a lot of that surveillance. They know there was surveillance. There was no, they didn't say that the car was there overnight, tying it to the apartment. They also. So in other cases, if there's surveillance, they'll have not only the buys, they'll have what appears to be a drug transaction that they add to their affidavit. We don't even have that here. There's also no details that you can see in other cases suggesting that the defendant kept a large supply of drugs at that. The CIs in some cases will say, oh, they have a large supply there. He's a known drug dealer in the city or something like that. By a reliable informant. Again, no reliable informant here. No information about the amount or value of the drugs sold in the past. No frequent visitors to the apartment or warning signs entering the apartment and anything like that. So in a recent case, which it's the dissent of Justice Henry, again, that I sent in a 16L letter, which it's the dissent, but I like her language. So she called it an inadequately general affidavit. And I think that's what we have here. An affidavit that could have more, should have more. the detectives just, there are good affidavits and they're not. And this is not a case in some of them, they say, well, they did the affidavit in haste, so it's because somebody was
Well,
securing.
what about the possibility that the affiant is intentionally making the affidavit vague so as not to disclose the identity of the CI? So the affiant could have said what the buy location was, could have said the time and date of the buy, precisely the time and date of the buy, but that would disclose the identity of the CI most likely. So what do we do with that?
Well, they still have to meet the threshold that there's enough, that there's a nexus to the apartment. They could do that with their, they don't have to have it just with the CI, they could do it with this additional information. Their additional information, our position is not enough. It's vague, it doesn't have times, it doesn't have any specifics, so, several surveillance. And a lot of it they have during this investigation, which 120 days out. When? We saw, oh, another one is, we saw him driving his Mercedes in New Bedford. Okay, so, it's too vague. They have to do better with their affidavits. The cases say that, and then over and over, we get affidavits that just aren't meeting the threshold. And again, does this court want to lower the threshold? The Commonwealth would like you to lower the threshold to meet this case, but our position is it's not enough here. Also for the Mercedes, our argument as well is that there's not enough there. There's no specifics that there were drug sales.
Was there any incriminating evidence found in the Mercedes?
No, except for money on his person. That was it. The money that was found in his wallet, the defendant.
Okay.
So there was two separate search warrants as well.
Right, but so it's a search of, the search of the Mercedes didn't uncover any evidence that needed to be suppressed.
Right. So if there's no further questions on that. So the Upton, the second argument having to do with the search warrant, it all has to do, I think what we've agreed, both the way we both argued our briefs is it all comes down to those CIs, those two controlled buys, and, what the police investigated, and as I've just argued, that there's just not enough to even satisfy the Upton standard for the first issue. So moving on to my second issue, which is a cumulative effect of improperly admitted evidence, that in this case, there was evidence that came in that shouldn't have come in, and the cumulative effect of all these different things that shouldn't have come in, prejudiced the defendant. So the first one is the opinion testimony of precipient witnesses. There was no need to get answers or questioning from by the prosecutor of the precipient police witnesses about specifically, items seized during the search. Okay, they can say what the significance are. They can't testify as an expert. They weren't qualified as experts, but the Commonwealth did have their own expert. They had the trooper who came in to testify as an expert to explain those things. So here they cut a little too close. Compounding, we had the lead detective, Barboza, talking about drug distributors will package narcotics, including cocaine and fentanyl, putting it in corner baggies and ripping them down, and then the ADAS. And those were the sort of bags that were depicted in that photographs recovered from the trash can, and referring to the first exhibit. Yes, and that was supplied to the jury. So he's basically saying, this is how drug distributors package their goods, and this is the same facts of this case. So he's vouching for the Commonwealth's case. Also, Detective Lagoa found 2 plastic bags that he believed were fentanyl. That's something that is left for the jury to determine. Again, compounding, Detective Barboza. And then Detective De Silva, same thing, talking about the different items found and what they're used for. His is a little less than the other 2, I will say, but he does talk about his familiarity with items used to ingest, so like if it was for personal use, fentanyl and cocaine, and he talks about syringes, spoons, and pipes, and he articulated that no such items were recovered in this case. So they're getting a little too close. Our cases say that they should be more explanatory, not conclusory, and where the Commonwealth had an expert, these prosecutors should talk to her witnesses and say, you can't get cutting too close. Commonwealth argues for my whole second argument about this evidence coming in, but there's overwhelming evidence. But if there's overwhelming evidence in this case, why are they cutting so close? Why are they, letting in this evidence that shouldn't come in, or, just be a little more careful, Commonwealth. Second one, same thing, calling the defendant the target of the target of the search warrant. There was a motion in limine, and the judge said, okay, we're going to keep out target, and the prosecutor said, well, I'm not going to call it, we're not going to refer to him as a target, and again, we have, multiple times where the detectives refer to him as a target. She said she wasn't going to do that, they do, and when he objects, the judge just says, doesn't sustain the objection, so, and then at the end, there's also a jury question about, specifically, was the warrant for the defendant, or was it for just the car and the home? And the judge told them to rely on their collective memories. 29 minutes later, they returned a verdict. Another one would be the photo of the drugs and the money that was found in the Mercedes. There's a photo of the drugs which are found in the house in a Versace, all the drugs found in a Versace eyeglass case with the money found from the defendant, and we have testimony from the expert that, if there's lots of money found with the drugs, with drugs, that's indicative of, distribution. And this was objected to by the trial attorney, and he said, they're trying to bolster their case. Why do they need that to do that? If they have such an overwhelming case, why are you just adding more prejudicial evidence for the defendant? He's entitled to a fair trial. So they could have cut that in half and had both, two different photos. It wasn't necessary. They also had, as I have in the record appendix, they also already had a picture of the drugs. Now, this was fentanyl, and fentanyl was not brought in for them to look at because of they didn't bring it into the jury room, so they did have those pictures. There was just no reason to have that.
Can I ask you just, since the time is short, I want to make sure you get to the third-party culprit.
Yes, absolutely.
What evidence was trial counsel able to get in, either through cross or through the defendant's witnesses, about Rafael Vega Jr.?
He was able to get it in through the defense witnesses, through Sonia Vega. She testified about him being at, that being using as his address, he's living there, things like that. And then he also was able to get through cross-examination that the police knew that it was, they knew who Vega was, and that they had investigated him before.
For drugs. Detective
Cross.
Lagoa said he...
And I think what the argument was made by trial counsel was the cross by the prosecutor of the defense witnesses took down that defense. So he wanted to be able to show that it wasn't just one of these witnesses who so the prosecutor later in her closing says is, he's here testifying on behalf of the defendant, so he's biased, so don't listen to what she has. So he was trying to, so through having this actual evidence of...
What was the exhibit that the defendant was seeking to admit, and do we have it?
You know what, I thought of that this morning when I was driving here, and I realized it wasn't, I don't believe, and I could have it sent up. I don't believe
Was it marked for ID?
It was not, I don't believe, and I will check that.
It's not in the record then?
So it would not, that's why I would have had it in there, and I thought of that and said, I don't have that.
Was it his certified conviction?
It was certified, right, it's in the transcript, this whole argument on it, that it was the certified record, and certified of his, notice of his probation violation.
What's your best case that says that to make out a third-party culprit defense, the defendant can put in documentary evidence of the third-party culprit's criminal history?
Well, I think I did not come up with, I don't think there is a case on it. It's just the third-party culprit cases. I don't think I came up with one. The trial attorney at the time was asked to come up with one overnight. I couldn't find anything. I guess like the one last point I want to say about that, argument is what the judge said, but I know you look at this, you all look at this differently, but he said, I'm not going to, without you subpoenaing Mr. Vega and having him come in, I'm not going to let those records in. Like, he referred to that, which I don't think is correct. There's no further questions. I rest on my brief.
Seeing none.
Thank you.
Thank you. We're from the Commonwealth. Morning again.
Morning again. Again, may it please the court, Stephen Nato on behalf of the Commonwealth. I'll begin where my sister did with the nexus issue, unless the court would rather start elsewhere. But unlike my sister, I think this actually is could have been more thorough, but a fairly thorough investigation that well establishes nexus to both the residents and less evidentiary significance, but the car as well. And certainly, as we acknowledged in the brief, the initial tip completely fails the Upton standard on its own, but it is the catalyst that begins the investigation. And I'll get to the controlled buys, which were obviously the most important part, I think, here. But initially, they corroborate the innocent details, where he lives, what he looks like, what kind of car he drives, the checks of his prior criminal history, begin to corroborate some of the more incriminating details, that he has a recent arrest in Brockton for similar offenses, and there's a body armor charge that goes along with that, 159 arraignments, which are not, I don't think, to be afforded much weight, given that they are only arraignments and only some of them are.
What do we do with the fact that Detective Barbosa was also the affiant in Ponte? And apparently, I understand this Ponte hadn't yet been decided when he wrote this affidavit, but we have another case where New Bedford police were apparently unaware of case law or where case law was headed. What do we do with that?
Well, I would suggest that that doesn't affect the overall viability of the warrant in this case, again, based on the totality of the investigation. So that particular issue, I think, does not render this one insufficient. And of course, the cases have to sort of depend on their own facts. But ultimately, we do get into the two controlled buys here, which are 3 months apart. The first one sort of closer to the beginning of the investigation, end of May. Second one in that first week of September, just before the warrant itself is requested. But significant as to each of those controlled buys is that it corroborates even more important details of that initial tip. First of all, there's a specific phone number that the CI uses to arrange a purchase with the defendant. As the CI describes, the defendant would leave the residence, get into his Mercedes, and drive to a prearranged location. And the CI indicates that this is sort of what's happening, this is sort of the routine of their interactions. And so the fact that you have one exactly as described at the beginning and one at the end, just before the request for the warrant, indicates quite strongly that this is an ongoing course of conduct by the defendant. So the precise timing is a little less crucial there. That having been established, some of those other details about the CIO, he's been reliable, not just about the innocent stuff, but about this much more material information about how the defendant is actually carrying out the operation. So I say Hardy.
Your opposing counsel says that the affidavit should have been more specific. It shouldn't have been as vague as it was. Why didn't the affidavit say where the Mercedes was registered? That seems like it's an easy detail. Maybe it was registered at this address, maybe it wasn't. Either way, it's something the police can verify and it wouldn't burn the CI.
That's true, but I think ultimately does not, given what does connect to the defendant to this specific residence, sort of whether he is registered to a different address, and indeed the trial evidence shows that there are a couple other addresses in play, but don't affect these.
I think the fact that the affidavit doesn't say that, so we would infer that the Mercedes wasn't registered to that address. I'm
sure if it had been, they would have noted that, but again, I don't think the nexus does not depend on the defendant living at that residence. There are a variety of things. They might use two separate locations, whether it's a stash house, whether it's someone that you're in a relationship that's just the sort of staging area. There are a variety of explanations for that kind of thing. Would have been helpful, but we just don't have that connection in this case. If there are no other questions on nexus, move on to the second issue, beginning with the asserted improper evidence, cumulatively depriving the defendant of his right to a fair trial. First, the opinion, so-called testimony by various detectives. I would suggest that in each instance, that testimony is descriptive to sort of explain why, why the police grabbing, certain items out of a trash bag and not others. Some things that may seem innocent, latex gloves, scissors, sandwich baggies. Why are you, as the searching detective, grabbing those things as opposed to other things that you might have picked up? So appropriate testimony on that basis, but in any event, certainly the DRE, or the drug expert, testimony renders all of it cumulative anyway, and given, the overall evidence in this case, the drugs that were found on the nightstand next to the picture of the defendant at the wedding, where in the same bedroom where his Social Security card, his birth certificate, are all located, are powerful evidence. So, and this goes to kind of all of these evidentiary claims, even if there is an error.
What about the prosecutor saying, we're not going to refer to him as the target, and then they refer to him as the target?
Clearly an error. Obviously, that was hashed out in the eliminate stage, and I think sometimes in the course of testifying, these common terms that officers use probably unthinkingly just said that it was, but again, it sort of helps to
How many times did that come up? It was referred to as the target?
Sorry?
How many times was he referred to as the target?
3 or 4. If I'm not sure on the exact number. But again, given the facts here that they are setting up surveillance outside this, or they're getting ready to execute the warrant outside this particular residence, and that the action they take once the defendant leaves the residence, gets in his car, including, breaching his car window to get him out of it, makes quite clear that he is indeed the target. So, that's a conclusion the jury could certainly reach itself. So harmless, notwithstanding that word should have been avoided.
Even though the jury then sort of asked about it?
Sorry?
But then they asked about it during deliberations?
I'm sorry.
During deliberations, they asked, was it an arrest warrant? Was it an arrest warrant for him, or just a search warrant? Is that
Search whether the warrant was for.
Okay.
I can't remember the exact wording.
But that's sort of focusing on did the police suspect him to begin with?
But to the extent they're asking that question, there's no sort of information about, what led the police to, to center the investigation on him. But the evidence was clear independently that the investigation had centered on the defendant, irrespective of the word choice here.
So why shouldn't the defendant be able to put on evidence to suggest that Vega Jr. was a drug dealer?
This is the third party?
Yeah, third party.
So in this case, I think it was the vagueness of the proffer here. First of all, I think there was one certified document that was the 2017 conviction, which, as the trial judge noted, referred not to the target residence, but to an address on, I think it's Coffin Avenue in New Bedford. So that doesn't even connect to the target residence here. It's 2 years prior to the incidents in this case. We have no information about, the underlying facts of that case, including the method of operation, whether anything is similar. So it's just too remote, too vague, and the defendant can't escape the consequences that they're just no connection there in this case. And you know, not the main point, but also the judge was clearly sort of aware of the underlying investigation, that, you know, he's not bound by the rules of evidence, just like this doesn't bear on the facts of this case, the way the controlled buys were conducted with the defendant, that sort of thing. So again, harmless to exclude that information, and I would note too that the probation violation, the notices of surrender, I believe those were not authenticated, those I think were not certified in any way, and have no.
Do we have evidence of that in the record as to whether they were certified or not?
I think he said those weren't, I may be mistaken, I thought he said those were not.
Okay.
Or at least he only mentions the conviction being certified, so I may have assumed. But we have no, I don't think there's any indication of what the violations were for, if it was for continuing offenses or technical violations. Money is not showing up to appointments and things like that, so that doesn't kind of renew this conviction that, you know, it was from a couple years prior, and again, that we have no information about. So certainly no basis there for admitting, even though there are constitutional concerns. But again, given the strength of the case, and given the fact that the Commonwealth's case did not depend on excluding all males from the residence, it was, you know, the defendant's connection to this particular bedroom, which, again, I know he had a sort of improbable explanation for how those documents got there, but, you know, his R&V records, his tax documents, motor vehicle citation, again, his social security card and his birth certificate are all in this bedroom. That's powerful evidence connected to all these drugs, that there is no other third party involved. At least the defendant certainly had constructive possession of this drugs in that case. If there are no other questions on that issue or any of the others, I would rest on the brief.
Okay, thank you. Thank you again. Thank you both. Case is submitted. So we're going to hear one more case before the break. And again, people in the DCF case, mark this date. It's March 7th, 2024, and you're being heard before the recess. The next case is going to be 2023P679, DCF against mother and father. Right. And I'll just remind experienced counsel that this is an impounded case, so don't refer to anybody by name. We can father, mother, the two younger daughters.
Yes. Good morning, Your Honors. Joan Altamore representing the father in this matter. This is a case where the parental rights of the father and the mother were ordered terminated by the juvenile court, and based on claims of alleged longstanding patterns of parental unfitness, failure to participate or benefit from services, and an inability to meet the two young children's needs. Father has two arguments before this court. The first one being that there is no nexus between father's temperament and any potential harm to the children should he be granted custody. Because parents embrace ideologies or pursue lifestyles at odds with the average is not a basis for denying the parents custody. Parental custody of their children is a fundamental liberty interest which does not evaporate simply because they have not been model parents or lost temporary custody of their child, or in this case, children, to the state. Factors relevant to a determination regarding termination of parental rights include a parent's character, temperament, conduct, and the capacity to provide for the child in the same context as the child's particular needs. The inquiry is whether or not the parent will place this child at serious risk or harm, abuse or neglect, or any other activity harmful to the child. The trial judge took father to be aggressive, defiant, and combative. before her during the trial of this case. Father states that he loves his children, and in one aspect, naturally, he would be aggressive and combative when faced with a court which is looking to terminate his parental rights. His tone may sound aggressive with the court, but his tone with his children is quite different, which is shown in the testimony that he provided to the court, as well as the social worker provided to the court, where there was testimony about his visits with the children, that the two girls regularly see him, come up, embrace him, they pay attention to him, he doesn't have a bad tone. The social worker testified that on multiple occasions during his visits that the girls listen to him, they come to him freely, voluntarily, and express their love to him. There are no actions taken by father which would show that he is aggressive towards his children.
Being aggressive towards their mother is not a good thing.
Your Honor, first off, the parents, the mother and the father, are no longer in any type of romantic relationship. They are simply willing to co-parent at this point in time. They have been living apart essentially since the first removal of these children. Father, there is no current domestic violence history, and contrary to what the judge said, the father has been addressing the tasks on his action plan. Yes, father was incarcerated for a period of time, but once he left that incarceration, he actually voluntarily checked himself into a facility to address his mental health concerns because, number one, he had lost custody of his children. 2, he had been released from incarceration. 3, the romantic relationship with the mother was no longer present, and he had 2 recent deaths in his family.
What facility was that?
Your Honor, off the top of my head, I know I have it in my notes.
And is the evidence of that his testimony?
No, I believe that the department did confirm that he had checked into that facility, Your Honor. It was a name known, and I believe it was in the Cape Cod area. I'm going to say New Bedford, but I may be mistaken.
So you argue in your brief that he's made significant changes to his lifestyle and behavior after getting out of...
Your Honor,
so
that's
one of them. What else?
Thank you, Your Honor. So in completing his action plan task, first off, he has stable housing. He has stable employment. The fact that he is currently living with somebody but has testified and told the department on multiple occasions that he is absolutely in a position to change his housing should he be granted custody of his child. He has the same type of employment that he had prior to, where he was providing for mother and the children, providing for his first older daughter, who is no longer a party to this case, who did get reunified with the mother. He has no open criminal charges, so he has changed that path of his life. He has no pending charges. There are no current concerns for any type of criminal activity. In fact, his testimony, and I quote, was, "I tried to keep out of trouble as much as possible," because he does understand, based on the therapy that he had actually prior, he did have a long period of therapy where his preference was for in-person therapy. And he continued that therapy for, I believe, in excess of a period of a year to a year and a half. And then his therapist left the facility. Things, because of COVID, went to virtual, which he was not comfortable with. There are no current concerns about illegal substance use. If the court noted back when this case first opened, the actual removal of the children was predicated based on a failed drug test by father. The department hadn't been involved with the family, but the reason for the removal, the initiation of the removal, was because of his alleged drug use. He testified that he does not currently abuse any illegal substances, and there is no testimony or evidence in the exhibits presented to the court that shows that there is ongoing concerns for illicit drug use. Granted, saying this is a gentleman who is well over the age of 21, he is able to drink alcohol because he is over the age of 21, but he testified, and again, there's no testimony from the department about any alleged abuse of alcohol moving forward. The father visited.
He's in his 40s, is that
He
right?
was in his 40s, Your Honor. And he was in his 40s at the time that these children were removed, at the same time for which he was holding down full-time employment, but drinking after work. One of the points made was that this father has not been the full-time parent for these children, which is absolutely incorrect as well. This father and this mother, when they were involved in their relationship, which extended over a period of close to, at this point in time, it would be 20 years, but basically going back about 15 years, because the elder daughter, who's no longer a party to this case, he was parenting her with mother. And he was working full-time at that time when that child was young. And, Your Honor, I see that my time is coming to a close, and I would
Actually,
just say...
it's passed, so you can sum up.
Just father seeks to have custody of his children. He expressly told the court he does want custody of his children, notwithstanding that the judge said he expressed he did not. In the alternative, father completely and fully supports mother in her quest for custody of these children. Thank you.
Okay, thank you. Attorney Katz, good morning.
Good morning, Your Honors. Daniel Katz for the appellant mother. This court should reverse the judgment of the lower court because the judge abused her discretion in deciding that, 1, DCF made reasonable efforts towards family reunification, and 2, that the termination of mother's parental rights was in the best interest of the 2 younger children. At the first American with Disabilities meeting, which was requested by mother, the recommendation was that mother undergo a neurological, psychological evaluation. Mother complied. The evaluator, Dr. Walbridge, concludes as follows, and I'm going to read it to you. It cannot be understated that mother does have the capacity to be a good parent, and now I'll paraphrase, not just a parent who can offer minimally acceptable care, those are my words, as long as she has substantial ongoing services in the home and outside of the home to support her. So this was in 2019, Dr. Wahlberg. 2 years later, at trial, the ongoing social worker, Bartlett, testified similarly, with ongoing, I quote, with ongoing and substantial support, mother would be able to parent effectively. And again, I offer my little sidebar. Social worker Bartlett didn't just say, which would certainly be sufficient, she could be a parent who offers minimally acceptable care. She said an effective parent. So what happened in those intervening 2 years? I'll tell you what happened. What happened was the department and the judge both failed in their respective obligations. Supreme Judicial Court has mandated that DCF must match services with needs and that the trial judge must be vigilant to ensure that it does so. At that first ADA meeting, DCF Supervisor Granger admits that she did not contact Dr. Walbridge to discuss the results of the neuropsychological evaluation. In fact, no one from the department contacted Dr. Walbridge. How about that? Is that living up to that obligation? Supervisor Granger also admits that it would have been important to do so. Well, boy, yes, it would have. Not only it would have, it should have.
So what service did your client not get because of this, of missing out on this?
So Walbridge recommends that she should have speech therapy, cognitive therapy to address cognitive defects associated with this car accident, which occurred in 2012, which the department knew, there's evidence that they knew at least in 2017. Mother was rejected from the SHIP program, a program of this great Commonwealth specifically addressed to parents, people with traumatic brain injuries. Why was she rejected? Because there was no documentation of a medical diagnosis of a traumatic brain injury. Well, how about that? The department made zero effort to obtain such a documentation. Clearly, that's in violation of their obligation, with both Bartlett saying 2 years after, oh yes, and I'm quite angry, quite frankly. Yes, the department thinks that with with ongoing and substantial services, she could be an effective parent. And yet in those 2 years, they did nothing. And there is this program they know about. Bartlett says, yes, perhaps it can help her. And why is she rejected? Lack of documentation. No medical diagnosis of a traumatic brain injury when the department knew that this injury, which occurred from an auto accident in 2012, and they knew, at least there's evidence that they knew, at least in 2017, that there was this accident, and they failed to obtain any medical documentation for mother who complied with this neuropsych evaluation, and there is this program, the SHIP program, and she is ineligible, and the department failed miserably. The department also failed miserably because
Can you, Mr. Katz, real quick, can you address the other side says that this was not raised until on appeal?
Okay, here you go, Your Honor. Mother requested meetings for reasonable accommodations according to the ADA.
And they had
Those meetings were had, yes, but termination cannot happen according to the Supreme Judicial Court if the judge fails to make a finding that whatever unfitness is, whatever deficiency is there, may be only temporary. Look at Chad, okay?
And the question was,
But the question is this, Your Honor. The judge, they failed in their obligation. She brought it up. Therefore, what is the department supposed to do?
no, I understand.
Oh, we don't want to make any more effort?
The question that I asked you was, did you raise this below?
Yes.
Could you tell me where?
In asking for the 3 ADA meetings. If you're saying that is not sufficient, then you're saying that the department can then say, oh, it's okay. We held these meetings. We don't have to do anything. But then the judge fails in his or her obligation in determining whether is this unfitness, is this deficiency temporary? Well, golly gee, look at Chad. Look at Alona. This is a mandate. A termination cannot occur if there is no finding that this, whatever deficiency, may be temporary. And here, when the department fails to obtain or assist her in obtaining documentation for the SHIP program for any traumatic brain injury, where they fail to get any diagnosis of any mental health, so therefore she's rejected from the Department of Mental Health. Or are you telling me that there was no, at the time, the department made no effort? Because Bartlett says, or Granger says, oh, we didn't have a neuro person available.
What do we do with the judge's findings around finding of fact 46 and 47, that the mother was seen by a neurologist every 6 months after the neuropsych evaluation, but she never informed the neurologist of her TBI diagnosis, and she seemed to minimize its effect? What is DCF supposed to do in that situation?
What DCF is supposed to do when they explicitly say that this mother can be an effective parent with ongoing and substantial services is not to drop the ball when there is certainly the SHIP program, failing to get a medical diagnosis, failing to get a mental health diagnosis so that mother can't go forward with this. Even if you say that, even if you say, okay, mother is at fault for doing that,
No, but I'm not saying she's at fault. Should somebody from DCF go with her to the appointment and say, this neuropsych says she's got a TBI, you should treat her for the TBI, don't listen to her? When she said she doesn't have one?
They should do more than they did. They can't just wipe their hands, which what they did in this case, knowing way back, A, this mother has cognitive limitations. B, she had an auto injury. And you're telling me in the city of Boston, in the Commonwealth of Massachusetts, with allegedly some of the greatest hospitals in the world, that they didn't have anyone or they couldn't make a little bit of an effort to find someone to give her a medical diagnosis when there was evidence that she was a fit parent of those two young children, both in their love, expressions of love towards her, and her ability, even before they were taken away, even though she was late for some of the doctor's appointments, she made them. There's evidence that at least the middle child appeared clean and comfortable. And there's evidence, not all the time, that she was able to redirect them. You can't have a social worker from the department say, oh, she can be a fit parent without certain services, and then dropping the ball with the SHIP program, with DMH, and you're telling me that there was no way to get... No, I'm speaking to the department.
Okay.
Because this case made me really upset, that there's no way that they couldn't get around the DSS determination that you need a specific IQ lower than 70, and they couldn't help that. Thank you.
Thank you. Okay, we'll hear from the department. Attorney Price, good morning.
Good morning. Can you hear me?
Yeah. Bend it up, though, since yeah.
Can you hear me? Good morning. May it please the Court. Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the decision of the lower court that terminated mother and father's parental rights. There was ample evidence of the parent's unfitness, and the trial court's findings went largely unchallenged. As far as father goes, it was not a matter of him being disagreeable with the department. It was a matter of him not cooperating with the department or completing any of his action plan tasks that were recommended. That was sufficient for the trial court to consider as far as evaluating his fitness. As far as mother goes...
Let's stick on the father for a second. How do you respond to the father's argument that he voluntarily checked into a facility, he got stable housing, he had a long period of therapy?
Before May 2020, father was involved in some therapy. That is true. Within that period of time, he showed up at his therapist's office in crisis and was recommended that he go to a crisis stabilization program. And he did, and he went there for 3 weeks.
Is that the voluntarily check into the facility that she's referring to?
I believe so.
Okay.
After May 2020, when he was released from incarceration, he had no further involvement with services. That was one of the judge's findings. And that is what was part of the basis for the unfitness. Where father was non-cooperative and non-engaging, conversely, mother was the opposite. She was involved in a number of services and a number of programs. She looked for more services to be provided to her. At one point, she asked if the department would stay involved with her case so that she could have services until the children were 18. The issue was not her involvement in services, her effort, or her sincerity. It was her capacity to parent the children. And that ultimately was what was found, that she did not have the capacity to keep them safe. She has profound impairments, and in response to that, she received many services over approximately 3 years. They were-
So how do you respond to Attorney Cass's quiet argument that, that the DCF could have done more to get into the SHIP program?
The SHIP program, she applied to the SHIP program. The SHIP program found that she was ineligible. That information, at least in part of the judge's findings, was not conveyed to the social worker. If it had been, I don't know what the social worker necessarily would have done, except possibly reapply, which I think is what happened with the application with DDS, the Department of Developmental Services, which was denied twice.
Was there some follow-up by the social worker? In terms of her ineligibility and the evaluation? I mean, or did the department put the burden on the mother? Or
The department didn't put the burden on the mother. The service providers that were working with mother helped her to apply to these programs. It's the program's decision whether she meets their criteria or not. But the department was working with her as trying to help her with her parenting skills and her capacity to care for the children and understand their needs over a few years, 3 years, if not more, without any observable changes in her capacity to take care of the kids. That's ultimately what the concern was. The department met with her over the ADA meetings. The department, as well as her team, because she wasn't alone, the department met with her, her social worker met with her regularly on a monthly basis. They had foster care review hearings and permanency hearings. There was plenty of time for her to, or her team to advocate for specific things. The judge found that as a result of the ADA meetings and as a result of the other meetings that were taking place, the department met the reasonable efforts to try to help mother improve her ability to parent. This was not a case where there were reasonable efforts were needed. There were reasonable efforts. What this case required was heroic efforts, and that is beyond what is called for from the department.
You had started to say that there was an instance where the mother was denied from a program, and then there was another effort at it, and then she was accepted?
No, she was not accepted.
Oh, even after a second effort?
Correct. She was denied from the SHIP program for not having a record history going back far enough to high school, I believe, and there was a different set of criteria that she did not meet for the Department of Developmental Services. Her application to the Department of Mental Health was also denied, but the record does not sort of get into the reasons why. I would just say in closing, because I know my time is short, the fact that a number of different people that were involved in helping mother all came to the conclusion that she could parent if she had substantial, intensive, ongoing assistance indefinitely is unfitness. If she had the services that...
Don't you, I mean, in terms of reasonable accommodations and the ADA, et cetera, I mean, somebody who needs, a parent who needs some assistance in raising children is entitled to that assistance, right? They're not, if they can, in other words, if they can be fit with assistance and you've got a cognitive disability, so you need assistance, you can't say, well, she can't do without assistance, therefore she's unfit.
The purpose of the assistance and the services is to get a parent to the point where they are able to parent their children. In this case, the services that she would have needed would have substituted for her as a parent, rather than correct her deficiencies.
Is there ever a situation where someone is provided sort of unlimited assistance until the children turn 18, the request that you had mentioned?
Not that I am aware of. I would point the court to the adoption of Lenore, which deals with a similar situation, and the parents were found unfit. If there are not other questions, I would rest on my brief.
Okay, thank you. We'll hear from Attorney for the Children.
Good morning, Your Honors. May it please the Court, my name is Julia Healy, and I represent the appellee children in this matter. The Court properly found that due to Ms. R's cognitive limitations, she simply lacked the capacity to meet her children's needs and provide a minimal level of acceptable care for the children. She had poor understanding of basic vocabulary words, was unable to follow basic tasks, and had poor retention of information. DCF made beyond reasonable efforts to reunify this family. They offered services specifically tailored to meet Ms. R's needs. She had a therapist, an IHT team, a family partner, a support group, a neuropsychological evaluation, over 2 years of a parent aid, ADA accommodations, including all of her services and communications in writing, extended parenting time, including a parent aid at parenting time, and social work collaboration with collaterals before parenting time to go over any needs that she may have. Sadly, and I say sadly, with all of these services, Ms. R simply remained unable to recall or apply what she learned in services. She remained struggling with basic parenting tasks, and she remained unable to assess her children's needs. When her older daughter turned blue and began vomiting in front of the DCF social worker, she did not know what to do. The DCF social worker had to take actions to save her child's life. She did not understand her children's basic medical needs. She struggled with simple parenting tasks. She did not change her children's diapers at visits. She could not bring food to which her children were tolerant. She was not able to control her children at visits. One of her the younger child, I believe, was almost run over by a car during a visit due to her lack of discipline. That same child, I believe, threw rocks at her. They acted out before, during, and after visits, and at time of trial, they had refused to see her. The court correctly concluded that Ms. R simply could not parent without long-term, indefinite, daily, substantial support that did not exist. Yes, the neuropsychological evaluation agreed with that. Yes, I believe the social worker agreed with that. But as my brother said, or I'll go beyond what my brother said, if the services do not exist, unfortunately, they do not exist. I wish we lived in a world where they did. I believe the court wished we lived in a world where we did, as did DCF. But they don't. Ms. R agreed with that.
What about this SHIP program?
Your Honor, the SHIP program, what I remember of the SHIP program, and I apologize, it's not my highest point, but what I recall of the SHIP program is that you needed a diagnosed IQ of under 70 by a certain age. And forgive me if I'm misspeaking, but I believe you did. I believe those records were held at her school, her high school, and they were destroyed. And they could not be, obviously they could not be recreated. That is my memory. I don't believe there was anything DCF could do to create records that SHIP needed. Again, Your Honor, I apologize, it's not in my notes, but that is my memory.
I'm not sure if it's the SHIP or a different service that had the IQ requirement, but then there's also a neurological exam requirement.
I'm sorry, Your Honor.
I
misspoke. I don't mean to interrupt, Your Honor, but I did misspoke. She was denied SHIP services because there was no formal TBI diagnosis. The DDS services, she did not have the documented IQ of 70 or below, and nothing in the record shows that DCF could have remedied that. But the SHIP, there was no formal TBI diagnosis, which my understanding is Ms. R did not tell DCF, or did not tell her own neuropsychological evaluator about that diagnosis. She herself downplayed that diagnosis. I'm not sure there was anything else that DCF could have done, given the fact that mother did not take it onto herself to give that information to her evaluators. If a parent isn't forthcoming with their medical information, I don't know what DCF could have done to get around that. So I do apologize, Your Honor. Ms. R. herself agreed that she needed the kind of supports and asked DCF to stay involved in the children's lives until they were 18. As my brother pointed out, that is not what these cases are about. These cases are whether or not a parent is able to provide a minimal level of acceptable care for their children on their own, which she unfortunately was not, and there were no services under which she could be. Turning to father, the court correctly found that his aggressive behavior, willful failure to not visit his children for 17 months, and his 17-year criminal history all placed the children at serious risk of abuse or neglect and were relevant predictions of his ability to parent his child. There are three children. The older one is not a part of that case, but he did at one point climb in bed naked with the older child. He climbed in bed with the older child while she was naked and touched himself in front of her. He's threatened DCF to the point that they needed a police detail, both at the courthouse and at the office. He was violent toward Ms. R., and he did not visit. 2 months prior to the trial, he texted his social worker that he needed to get money, but if she got a 50, he would smoke it with her. He clearly had a substance abuse issue that was not remedied at trial. He stated that he had to drink, that his drug use wasn't that bad, and was incarcerated for 7 months over the course of the case and had a criminal history dating back 17 years. The court correctly found that he had not changed. The court correctly found he did not complete any of his service plan tasks, which he called a joke and a nonsense list, and he told DCF that he would do anything to get his children back except engage in services. He did not do any services after May of 20. Finally, the court correctly found that it was in the children's best interest to be adopted by their pre-adopted parents. I will try to tell you about them in the 1 minute that I have. At trial, the children were thriving in their pre-adoptive homes. Their foster fathers had been married for 15 years. They had expressed a lifelong commitment to the children. They responded to all of the children's needs and were excited to adopt them. The children felt safe and happy in their home and were out of control happy to see their father at daycare pickup. They did very well with the structure and support their fathers provided, and the then 5-year-old child said she wanted to live with her foster fathers forever. And if there are no questions, I see I'm short of time, I will rest on my brief. Thank you.
Okay, thank you. Thank you all. The case is submitted. So at the moment, we're going to take a 15-minute recess. We'll be back at 11:25 to hear the KLIGLER case and then the Clark case.
All rise. We'll stand in recess.
Ongoing cases. That's when I came in.
Thank you. And so fourth case for today is 23P809, Roger Cligler, MD versus the Paul Revere Life Insurance Company, and another. And Attorney
Feigenbaum.
Eigenbaum. Morning.
Thank you, Your Honor. Good morning. May it please the Court, my name's Jonathan Feigenbaum. I represent Dr. Cligler. Dr. Cligler paid 2 distinct premiums for 2 lifetime disability benefits under this insurance policy. And I'll explain to the Court why Paul Revere Life Insurance Company owes Dr. Cligler $13,300 a month, 2 times, each for the rest of his life. The policy does not say, as Paul Revere suggests, and the trial court found, that once Dr. Cligler turned 65, the rider page 858 form reduced his benefit by 70% to $3,990 a month. That was a plain error of law. The rider does not override the rest of the policy, and let me explain why. And the best way to do this, I find, Your Honor, if it's a good use of our time, is to go through certain parts, or Your Honors, certain parts of the policy. There are 5 key parts of this insurance policy that require examination to get to the correct result. The premium summary, the table of total disability benefits, policy schedule 2, table of additional benefits, and then lifetime rider 858. So I'd like to begin with the premium summary, which is, it's embedded into the brief on page 17. In the record appendix, it's actually page 12. But in looking at it, it says premium summary. You can see that Dr. Cligler paid $4,724.27 per year for a total disability benefit. He then
Wait.
paid-
What's that number? I don't see that number anywhere. Say that again. I see.
Well, if you're on, which page?
I'm on RA 12.
On 12, do you see premium summary? Annual premium, it says annual premium for total disability benefits, $4,272.24. I said it's 27.
Okay, right. That's the. So right. So there. It seems so. That's like the main thing. That's the biggest chunk there, right? Is that 4272, and then another $1,000 for additional benefits.
Correct.
Which so for one $4,000 premium you get $13,000 a month for life, and then for just an additional $1,000 you get another $13,000 for life.
That's how the policy's written. Now it may.
Doesn't just on a facial basis that seems like not to make a lot of sense that you could get a second full lifetime benefit for a quarter of the price of the regular one.
I understand what you're saying, Your Honor, and the trial court raised this in the trial court's memorandum decision. It's wrong. We're not supposed to guess and pretend that we are actuaries setting premiums. It may not make sense. There are a lot of things in insurance may not make sense. It's not a fair conclusion to draw.
So
Go ahead.
Go ahead. Well, so total price it says for total disability plus additional benefits $5,311, and then there's a asterisk select preferred. He's getting some sort of discount?
Correct.
Okay.
Right.
What's
There's
the
various
discount?
reasons why insurance producers say we'll give you a discount.
Okay.
There's a myriad of reasons.
Okay.
Frankly, it's a sales technique. Because if you sell to a group of physicians like Dr. Cligler, I can say, Dr. Hamilton's buying it,
Okay. All right. So
Dr. Feigenbaum's buying it, and so forth, and what's offered is some type of discount. So in any event, you can see there are what I'm calling 2 distinct premium payments he was making. So now I want to explain the first lifetime benefit.
Well, wait a minute, I have a question
Yes,
about
Your
RA 12. Then later, about halfway down the page, it says, the maximum benefit period may change due to your age at total disability. Please see policy schedule 2. That phrase, maximum benefit period, does maximum modify benefit, or does it modify period?
It modifies the period. That's one reading. I understand what you're raising, because it may not be 100% clear. It's modifying the period, which then means it's lifetime, because that's what I was going to go to next. If the table of total disability benefits, right, says if Dr. Cligler is disabled, he gets paid, it's $13,300 because of what are called future insurance options. It says to age 65, but we need to look at maximum benefit period, and there's an asterisk there, right? So we look at the asterisk. The asterisk language states, the maximum benefit period may change due to your age at total disability. Please see Policy Schedule 2. So if we turn to what's Record Appendix, page 13, it's embedded in the brief on page 29, we look for injury and sickness, total disability benefits starting before age 65, lifetime. So the correct reading of the policy is, if we turn back to the table of total disability benefits, we swap out age 65 for lifetime. That's how I get to the first benefit that is due to Dr. Cligler. Then, if we go to the table of additional benefits, this is where the second benefit comes from. If you look at the, again, it's Record Appendix page 12, it's page 19 of the brief. We have this lower table of additional benefits, something else. And in the left part, it says lifetime total disability. And again, that would be for $13,300. There is nothing about the word rider. It doesn't say see attached documents. And this is where the trial court erred in adopting Paul Revere's reasoning. Trial court basically concluded and said, that's obviously the rider. It's not. If Paul Revere wanted to incorporate the rider, it could have done so. And what was before the trial court was a copy.
The rider is attached to the policy, though, right? I mean, yeah, I get my insurance policies, and I get a whole bunch of stack of paper, and
Yes.
I just got these riders. So, I mean, and you don't dispute that the rider was attached to the policy.
The rider's part of the policy.
Yeah. And there's also, they point to the application where it's also written, like, that your client signed that actually references the rider.
Right, I agree. The rider is part of the policy. There is, I don't have it off the top of my head, but there's a definition in the policy that is close to what it says. Okay. It said it includes the policy, which I'd call the main document, riders, amendments, and the application.
And the rider is called lifetime total disability benefit rider.
Correct.
Matching the word there. Okay.
I agree.
And I agree, you're right, there's nothing on page, on RA 12 that says see rider.
Correct. And if you look at, for example, and it's in the brief, I just need to find the page quickly, you compare it to Dr. Eunice's policy. His policy issued, I believe it was June 21st, 1991. Cligler's issued April 17th, 1991. The policy was rewritten, and it is very different, and I've reproduced in the briefing on page 28 on the record, I can't tell you the page on the record appendix. It may be 295, I'm going from memory. But you can see...
That's the one with 61, 62, 63, 64, 65, is that?
No, that's not it, Your Honor. It is the table of additional benefits. And in Dr. Eunice's policy, if you look, for example, on page 28 of the brief, under the table of additional benefits, you see lifetime total disability in parentheses 858. Again, that's not the clearest, but here is the huge difference. If you turn to page 29 of the brief, which is, again, Policy Schedule 2 of Dr. Eunice, it says, you have a lifetime benefit rider added to your policy, which provides a benefit for as long as you live. Please refer to your policy for details. That language is absent from Dr. Cligler's Policy Schedule 2.
Can I just ask you about that?
Yes.
This is from Eunice, right? There's nothing. It says, like, it doesn't say anything about percentages or multiples or anything like that. It's kind of this weird list of 48 months, 42 months, 36 months? What, I don't get it at all.
Well, it has different numbers, but I'm telling you, in application, the trial court, it was,
Because in your client's policy, those numbers correspond with the multiples, right?
my recollection is what was argued in KLIGLER, I'm sorry, in Eunice, in the trial court and affirmed on this court in a memorandum decision. It was, I forget the judge's name, but what her name was at the time, it's Judge Kelly in the federal court now. That benefit was reduced under the rider, under the formula. So the rider was applied. The case was argued differently, so it's not very much persuasive authority for lots of reasons. But going back to...
Yours says lifetime.
Excuse me?
Yours says lifetime.
Well, they both...
Yeah,
there's no dispute here between the litigants that Dr. KLIGLER's owed lifetime benefits. You know, Paul Revere's position is he only gets $3,990 a month. And what I'm suggesting, the correct reading of the policy is he should be getting 2 payments of $13,300. So
I mean, you're not to be. So your argument on the lifetime total disability is we just ignore the rider.
it's not ignored. I want to explain why it's not applicable. It's because we have to look at the entire policy. I'm in agreement there. Let me explain why it's not there. So the rider is embedded on page 20 of the brief, the entire rider. It's also page 32 of the record appendix. So if you look at the rider, there's 2 reasons why it's not applicable to Dr. KLIGLER. And let me go through those. I don't know if you're looking there, it'd be helpful. Okay. So if you look at the lifetime rider, near the top it says lifetime benefits after age 65, and then you see 1, 2, 3. The following sentence is the key. This benefit, referring to the rider, will start on the later of A, your 65th birthday, or B, the date the total disability benefit payable under your policy ends. Dr. KLIGLER's position is because the benefit under the main clause of total disability benefits did not end at age 65, but was supposed to continue because of the reading of the table of benefits with policy schedule 2, the rider did not come into effect. That's reason 1. There's a second reason too. You need to skip down a little further down the policy, and if you look at the table of factors by age for total disability due to sickness, there's a key sentence there. If a larger amount is payable under this policy, and you notice the word P is capital, for the same period, the larger benefit will be payable in lieu of this benefit. $13,300 is larger than $3,990, so it's not. So the lifetime benefit under the rider should be inapplicable to Dr. KLIGLER's situation. The trial court just made a fundamental error saying 4 times the policy is clear. It's not. And the trial court also...
Let me just get back to that, the larger amount is payable.
Excuse
so
me?
If a larger amount is payable under this policy, and so there is a larger amount payable from the main benefit.
Correct.
But then the second part is the larger benefit will be available in lieu of this benefit.
Right.
So that seems to me you don't get twice, you just get 1.
No, because where I started out before, Your Honor, I said there is the benefit under the table of disability benefits when we're looking on page 12, and under the additional benefit, there is the second lifetime payment. That's how I said 2 payments are due to Dr. KLIGLER, and what I'm saying is the rider is not applicable to Dr. KLIGLER's situations. I gave a suggestion in the reply brief of a situation where the rider would apply. I can come up with other ones if the court would like to hear, but under the facts where Dr. KLIGLER became totally disabled effectively at age 61 and remained disabled at age 65, the benefit under the table of disability benefits continued for life, And then the second benefit under the table of additional benefits kicked in once he was once he turned 65, after his 65th birthday. Paul Revere and the district court and the Superior Court were incorrect when they decided that the Rider 858, you can call it trumps, overrides, replaces, but dictates the outcome of the case. And for this reason, the court should reverse and request that that Dr. Cligler get all the relief that's set forth on page 37 of his brief.
I just want to clarify something. You
Sure.
mentioned something about how the rider never goes into effect.
Well, I said for two reasons. On Dr. Cligler's facts, I mean, there's other situations where it might happen. There's two reasons. As I pointed out, it says this benefit will start to pay on the later of either your 65th birthday or the date the total disability benefits payable under your policy ends. Because what we'll call the main part of the policy, the table of disability benefits never should have ended at 65 because of the asterisks.
But then that would mean the one $13,000 payment.
Yes.
And would be all that he's entitled to. But it wouldn't be a double, because your position is that the rider never comes into effect under that interpretation.
Well, that's the first benefit, but as I said before, maybe I wasn't clear, the second benefit is under the table of additional benefits. He paid a second premium, and that premium then says there's a lifetime benefit in the exact same amount of money. If Paul Revere wanted the policy to say the rider controls when you turn 65, all Paul Revere had to do was add a sentence saying the payment under this section, the additional benefits, is governed by Rider 858. It's absent.
And again, your position is not that the policy is not ambiguous in any way. It's just that
the policy is what I would call contextually ambiguous, meaning when you read it as a whole, it's far from clear. What I'm suggesting is that Dr. Cligler's interpretation is reasonable, and under well-established insurance law, a reasonable interpretation of the insured is the one that the court is required to follow. The policy is an assembled, frankly, mess. It's difficult to reconcile. If it was clear, we wouldn't be here. And I'm not saying any particular word that's dispositive here is ambiguous, but contextually, when we look at the policy as a whole, it's far from clear. And because Dr. Cligler is offering a reasonable way to read the policy, it's incumbent upon the court to grant deference to his reading of the policy.
Thank you.
Thank you very much, Your Honors.
Without, I just want, without any indication of, it doesn't mean anything, but I did find the way you copied the piece of the policy in your brief to be effective. That was
Thank you, Your Honor.
Yeah.
Good morning. Joseph Hamilton for both the Paul Revere Life Insurance Company and Unum Group. May it please the court. I think the simple framing of the issue here is whether Paul Revere paid Dr. Cligler the correct amount of benefits after he turned 65. And the Superior Court found the answer to that to be yes. And as I go through this, I hope I can show the court that this is really a very simple analysis, not the complex, convoluted explanation of various policy terms. It's very straightforward as to how this policy works. And I think there's two key documents in the case. Obviously, one is the policy. That's Exhibit 1 of the record appendix. And the other one is Exhibit 27, which is the affidavit of Lisa Fagan, who is the underwriter from Paul Revere. And the reason that that affidavit, that's, I think I said Exhibit 27, is she goes through in detail the history of Dr. Cligler's coverage, and what he applied for and what he was approved for and what he actually received in that policy. So just to briefly go over that for the court, prior to receiving the policy that we're arguing about today, Dr. Cigler had a policy. And the key of that prior policy is that it contained only benefits payable to age 65. He did not have lifetime benefits with that policy. So he applied for coverage for a new policy, and that's attached to the policy. And he asked for 5 things. One is he wanted an increase in the amount of his disability benefit. And then actually 6 things. And then the other 5 are what's called optional benefits. Now, the optional benefits are listed, and it's actually called, it's under the question on page 35 of the record. And it says, describe coverage being requested. And you can see that there's a request for an additional $300 of coverage. And then to the right of that, the optional benefits. And there's 5 of them there. Now, all those were approved by Paul Revere.
Tell me, what is AIB and what is BMI? What do those stand for?
Yes. So AIB is automatic increase of benefits. And that is...
That's why we got 13,300 instead of 10,000.
Exactly.
Okay.
That's page 14 of the record, Your Honor. And
then the key one there, BMI, 858. 858 is the rider.
I'm sorry, Your Honor?
And it says BMA/858 equals 10,800.
Oh, in the corrections and amendments section?
No, I'm sorry, yeah. So what does BMI stand for?
Yeah, I think what was, so that's actually saying that the AIB was going to be, it was originally listed as 5%, then it was corrected to $500. So if you look at page 14, which is the AIB provision, it starts off by saying $500 will be automatically added to your benefit without evidence.
But right under that says BMI/858. What does BMI stand for?
I am not sure, Your Honor. I hadn't focused on that, and I don't think it's been raised in the case.
But it's 858 is, one of the briefs says 858 is the, you said, 858 is the rider.
It is. It is the rider. Yep.
So presumably the BMI has something to do with the rider.
Presumably it does.
Okay.
But I'm sorry, Your Honor. It hasn't been raised in the case, and I didn't investigate it. So one of those 5 benefits, as you said, was the AIB. The other was own occupation, which is changing the definition that Dr. Cigler would be examined. It would be whether or not he was able to do his own occupation, he would be qualified for benefits. So those are those 2. The other 3 are the ones that are referenced by form numbers. And those 3 numbers are 766, 784, and 858. So what are those? All 3 of those are riders, each of them. 766 is on page 27 of the record, and that's titled Future Income Option Benefit Rider. And then if you look at the lower left-hand corner of that page, you'll in fact see 766 is listed there. 784 is on page 31 of the rider, of the policy, and that's titled Loss of Use - Lifetime Benefit Rider. And again, has the corresponding form number on the bottom left-hand corner, 784. Then the last one is the 858. That's on page 32. Again, top of the page, Lifetime Total Disability Benefit Rider, and the form number on the bottom left-hand corner. So what Dr. KLIGLER had requested in his application is exactly what he received when Paul Revere issued the policy. Now, under that rider, there is a total disability benefit after 65 for injury and one for sickness. And like the Yoons case, there's a distinction as to how it's handled. If you become disabled for an injury, you get the full benefit after age 65, that's it. If it's a sickness, then it depends on the age that your total disability begins. If it's prior to age 55 or 55 or less, you get 100% of the benefit. Every year after that, it drops by 10%, as it's shown on the table. So in Dr. KLIGLER's circumstance, he was 62 when he became totally disabled. That's not in dispute. So he was approved after age 65 for the 0.3, 30% of his benefits, and that's how you get to the $39.90. So what the case is about, it has been about, is Dr. KLIGLER trying to avoid the application of that table to his benefit. And as we just heard, there are two arguments there. The first is the table of additional benefits. I'm going to address that first. That's page 12 of the record. And this, on this issue, there's really three reasons, at least, why Dr. KLIGLER is incorrect while claiming that's a benefit. First, if you look at that table of additional benefits, the first three things that are listed there is lifetime total disability, below that, future income option, below that, loss of use - lifetime benefit. Those are the three forms that he applied for and the three riders that I just went through. So those are the additional benefits that are referenced in that table. On top of that, if you look at its title, table of additional benefits, right below that to the left, above the listing of those benefits, it specifically says additional benefits attached. Again, a reference to, you've got three documents in this policy that describe those benefits. The third reason is, and this is just a well-established contractual interpretation provision, which is if you've got a provision in a contract, especially an insurance contract, that directly addresses a benefit scenario, that governs over any kind of a general argument someone wants to make about coverage. The specific governs the general. And the lifetime total disability benefit rider couldn't be more clear as to what it's addressing. It's a lifetime benefit after age 65.
But it does have that language about if a larger amount is payable under this policy over the same period, the larger benefit will be payable. And so you have to address, will you please address the argument that the total disability benefit, which is the main chunk of the premium here, which is in the middle of the page, refers to, has that maximum benefit period asterisk Schedule 2, and Schedule 2 seems to say lifetime.
Yeah, there's no disagreement that he has a lifetime benefit. He does have a lifetime benefit if he remains totally disabled. That's the fundamental problem with this reliance on the maximum benefit period, and it really goes right to the policy Schedule 2 argument, Your Honor. That talks about the maximum benefit period. It does not relate to the benefit amount. So everything that's there is completely accurate. If his total disability is before age 65, he gets a lifetime benefit if he continues to be totally disabled. If he's totally disabled from a sickness under the rider, he gets 100% of the benefit. if by injury, I may have misspoken. If it's by sickness, which is Dr. KLIGLER's situation, again, not in contest, then the table applies to it. So this whole concept that there's a second lifetime benefit of $13,300 because the policy Schedule 2 tells the insured that they have a continuing benefit is not supported by that language. It just tells you that your coverage will continue and that you will continue to receive a benefit. It does not tell you the amount of the benefit. For that, you go to the specific rider, which is referenced in the table of additional benefits. So, and as Your Honor mentioned, that what Dr. Cigler is trying to do is completely ignore the rider. The language that if a larger benefit is payable under the policy, that will be what's paid, means that if there's another provision in the policy or another rider in the policy that somehow pays him more than what he would get under the rider, it'll control. It doesn't mean that the insured can go back and say, well, you don't have the word rider in the table, even though it's referring to the documents attached, or it means that the policy schedule that tells you how long you get the benefit entitles you to an additional $13,000. That has nothing to do with this. Apples and oranges, Your Honor. So he's continuing to receive that benefit. He will continue to receive that benefit, and the rider controls. And indeed, even though the language isn't word for word the same as the Yoons case, it's the same situation. In both cases, the insurers have said, well, disregard that rider. I'm entitled to benefits because of how I read the schedule. The table of additional benefits is exactly what it says. It's a table. It's there to allow the insured to have a list of what's in that policy, and that's exactly what it was done. So I would just close, Your Honor, with a quote I recently saw in a federal court case here in Massachusetts, and it's from the First Circuit, and it's based on its view of, or its reading of the cases from this court and the Supreme Judicial Court. And the quote is, common sense is as much a part of contract interpretation as is the dictionary or the arsenal of canons. And that goes directly to this case. How any reasonable insured could pick up this policy and look at the table of additional benefits and say the benefits are attached, and come into a courtroom and say, no, ignore that rider. This one line, which I could have had an additional word, entitles me to a benefit, and this policy schedule entitles me to a second benefit. And by the way, when the 93A letter was sent, they were alleging a third benefit of $13,000, but they dropped that.
So just so I understand you, so you're saying if you look, I'm looking at the policy schedule. You're saying that the first, the top half there, the total disability benefits, which he's paying $4,227.24 with a little discount, gets him the maximum monthly amount, which we understand is $13,300, just to age 65.
Right.
Ignore that it says, and ignore that we go to Schedule 2, and it says if your disability begins before 65, it's lifetime.
Well, no, I wouldn't say ignore it, Your Honor, because I
think you're both asking us to ignore something, but
I'm saying it doesn't apply. I am not suggesting the court should ignore any provision here. My argument is that all policy Schedule 2 does is informs the insured that benefits continue after age 65 if they're totally disabled.
But that he paid for that with the additional benefits. If he hadn't bought the additional benefit, then it would stop at 65.
That's right, and that policy schedule would not read as it does. In fact, in the affidavit of Ms. Fagan, I think she specifically stated what the maximum, what the policy Schedule 2 would look like if the lifetime benefit rider wasn't obtained. So that table of total disability benefits says that's your basic policy, that's what you're paying your $4,000 for. And then there's the asterisk saying the benefit period may change due to your age. So check Schedule 2. And because he had purchased these additional benefits, in fact, that policy schedule did change, as reflected in 2.
Okay, well, thank you both. A really interesting and difficult argument, and your arguments and briefs are helpful. And the case is submitted.
Thank you, Your Honor. Thank you.
So to say good afternoon to the last case, which is going to be the Clark case, 23P747, Charles Clark versus Jeffrey Johnson, trustee of Old Hyannis Road Realty. So, Mr. Clark will be on this side here, and Mr. Daigle will be on that side. And just, Mr. Clark, you probably have never been in this court before.
Not this courtroom.
15 minutes per side, and we don't have rebuttal, so think of everything now.
Yeah, okay. Thank you for having me, Your Honors. I appreciate the time. I want to start off with basically, we're going to move into my appendix of the appeal, and I want to just jump into the elements of the law. And I made the draft that I appealed had a lot of the information in it, so I could make it more clear. So basically, if you went to basically page 29 and 30, this would be...
Let me just make sure we're on the right. There's a whole bunch of documents here.
Yes, that's why I'm doing it this way.
Because
it would be Exhibit 9.
This is your appendix?
Yeah, yes.
And let me see if I mean, because
that's the amended.
Okay, yeah, Exhibit 9, which is redemption by any person of 2 years, is that it? Document certificate from Mr. Seth Taylor?
Document.
So do you know what page number it is on the?
It'd be 2930.
2930, okay.
Is this the information about Matthew Hallett?
Yes, it's basically the redemption letter from Seth Taylor, the tax collector.
And that was back in 1850-something?
No, 1892.
Okay.
Is this the one that's highlighted also a certain piece of wood? Is that the one?
Yeah, that's the locus, but I want to go to the written information that Seth Taylor did. And of course, he gave the right of redemption to the property. And I want to clarify, his right was anything according to law. Now, the law means that he has to meet the elements of the law. So the elements of the law are the part is that he has to be a landowner. And of course, basically, the record information would be established that he had the information under the law of Matthew C. Hallett's probate records. And of course, the probate records of Matthew C. Hallett showed that sorry about the delay here. I apologize.
I didn't see anything in Judge Foster's decisions discussing Matthew Hallett or his probate records.
Well, of course,
Was this
because-
issue raised in front of Judge Foster?
No, the information was there. It's because the information was shown that it was part of the probate. It would have been how it describes in that document that T.T. Hallett had the right to redemption. That was his son. And he also had a grandfather named Matthew C. Hallett. And my grandfather was named Matthew C. Hallett. So that name should have been mentioned, and this is where a lot of information got set aside. So just to jump into, want to make it clear, page 13 in the, basically appendix, you'll see Matthew C. Hallett, the probate records.
Was this document at page 13, I see it's sort of a family tree?
No, well,
was
this is
this
a-
before Judge Foster?
It would be, it should show up as the probate records of Matthew C. Hallett.
Right. And so my question is, this information about Matthew C. Hallett,
It was all submitted. It was in my brief. It was all submitted.
was it submitted in the land court?
Yes, yeah,
Okay.
yeah, in the brief.
And so the page you were just showing us starts with number 3818, Matthew C. Hallett, Barn Co-Pro, is that?
Yeah, Old Hyannis Road, and with the, basically, if you can
Page,
see the inventory at the top
22.
here.
RA 22.
Okay.
Okay, so this was his inventory, and he had a lot of inventory in Yarmouth Port and Yarmouth in general. So a lot of the descriptions show the inventory. Now, if you jump to page 15 in the appellate brief, it'll show a description, and I did it in 3 ways. I gave you the original document. I also gave you a transcribed document so you could read the names. If you read all the names at the bottom of the document and at the top, it came from Edward B. Hallett. And Edward B. Hallett transferred all title rights and interests because it was his inventory out of his last will and testimony, and the controlling interest of all these documents occurred in 1857. This was part of his probate records. Now, what makes it very interesting, if you look at the last part of this document, it basically, Edward Hallett signed off for Thomas. Okay? Thomas had a 1/5 interest. I mean, Edward Hallett had the 1/5 interest. Thomas was who he was signing off for. So we retained that interest. You're going to find that in the other documents that come forward. Now, when the information of standing comes into play, you have to obtain to the interest of who has standing. Otherwise, you have no case. If you go to page 20, and I highlighted in the section, you read in the center of this thing, that's the 1/5 interest that both appellees claim they own. And if you notice, it also says heir of Matthew C. Hallett, because he also owned the rest of the interest. Now, as I've said all along, is the court had all this information at their fingertips, and they kind of erred on the idea that we weren't credible. And I blame it on the appellees leading them on a very safari hunt in the wrong direction, because this claims the interest in the property. So all the names that they say they had interest were signed off in the 1857 document, and the 1/5 interest is what Seth Taylor shows in the collector of taxes of the sale. So now you get into the elements of the law. It was section 43 and section 57. I include both. At one point, you realize that the law basically has 2 directions. Judge Foster said there was 2 elements of the law. And the question is, Seth Taylor said it was a redemption. Under the provisions, the only way that the tax collector could make a sale, he had to make it to an owner prior to the 2 years of statute of limitations. 2 years had to pass of taxes. Any time before that, you had to be the owner. You're now redeeming the property. If you're redeeming the property, you had to be the owner.
Who redeemed the property? Did Thatcher Hallett redeem the
Thatcher
property?
Taylor Hallett, the son of Matthew C. Hallett.
Where in the record does it say that Thatcher redeemed the property within those 2 years?
In the first document I showed you. Well, he said he had to meet the elements of it. In other words, if everything was according to record, he'd meet the elements.
But I think what Judge Foster is saying is that the tax deed never passed to Thatcher Hallett in 1892.
Well, the tax deed never met the criteria of a tax sale. If it met the criteria of a tax sale, it'd have to go over 2 years to be a tax sale. It was sold in less than 2 years. So when you sell it, in other words, when you deem a property, it never met the criteria of a tax sale.
Well, it was sold to Thatcher T. Hallett, right?
That would have been, yeah, my great-great-grandfather.
Okay. But you're saying that was invalid sale?
No, I'm saying it was a valid sale. I'm saying the court erred on the idea that everything was done according to law. The plaintiff, as the appellees have misled the court to saying that this was a tax sale, and it never met the criteria of a tax sale. Elements of a criteria of a tax sale had to be 2 years.
So what is it?
It was less than, I think,
So it's
8 months.
not a tax sale, so what is it then?
It was, I guess it was less than 8 months, if you do the math.
But no, if it's not a tax sale, I'm looking, so.
Oh, it's a redemption.
But that's not my understanding of what a redemption is.
Well, a redemption is when you owe taxes on a property,
Right.
and the town gives you the right to reclaim it.
Right.
So therefore, you already own it. All you have to do is make whole with the town, and it releases the lien against the property.
Right.
So why was there an auction? If somebody
Well,
had shown up
you
at the
gotta
auction...
remember, the laws have changed
If
all the time.
somebody had shown up at the auction who was not a Hallett, and they were
Well,
the
the
highest
question
bidder...
is, that was the way the laws-
Wouldn't they have been allowed to...
Oh, yes, they all would have been allowed to bid on it, but you got to remember is, during that auction, at any point in time, it says it in the laws, which I define in the brief, he can redeem it with any time during the 2 years of that sale. All he's got to do is pay the tenor of taxes, and we'll go to that.
And that would have dispossessed Thatcher Hallett of it? During the 2 year, if he bought it at the
Yeah, well,
auction?
he was the one that was the bidder,
Right.
and he bought it, and of course, he got the letter from Seth Taylor saying...
Before he bought it, did he have a 1/5 interest, and then he bought the
No,
whole thing?
he had, basically go in the respect of anything more than the people who own it. Now, Oliver Hallett's interest went into a trustee account 39 years later, and of course, they are claiming it through a Carl Adams, who already signed off his interest in the town of Yarmouth, and I show that in the parts of the brief. Now, this case goes back old, it's ancient. They're relying upon people not having this information, and they're relying upon that the information on file is they can make up what they want. They were misleading the court. They were trying to direct Judge Foster in believing this was a tax sale, and it never met the elements of a tax sale. And to clarify the elements of the tax sale is...
But ultimately, Judge Foster says this is not a legitimate tax sale.
Well, the question is, it was never a tax sale. It was a redemption under law. And a redemption under law means you have to be the owner, you have to pay the taxes, which was done, and to make it interesting, you'll find in the brief that I showed you.
But as of 1892, weren't there more Hallett heirs besides Thatcher who had an interest in the property?
Yes, that was the 1857 document that they all signed off to Matthew C. Hallett.
So I don't understand how you're saying that what happened in August 1892 was not a tax sale, but a redemption. If
Well,
if Thatcher Hallett was not the sole owner of the property before that transaction, that August transaction.
Well, the idea of the tax sale in 1892 is how they basically cleared property. And when they took this property, it was from the owners of what you got to understand is this is probably an unusual case in the respect if you heard. People back then owned what they called tracts of land. And basically, the tract of land would mean that the heirs had to sign off. Now, to jump into page 42 of this, you'll find this was recorded in 1984, and this was my mother's deed showing the payments to the tax collector. And I personally found the checks upstairs in my grandfather's inventory, where he paid the tax collector, paid all the interest, paid everybody what was owed.
As I understand Judge Foster's rulings, that information might be relevant in the future for the judge to decide, for example, if there's an adverse possession argument, that
Adverse possession doesn't come into play if there's no viable interest to obtain. Matthew C. Hallett owned all the interest. The only other interest was Oliver Hallett's interest, and that was unattainable through the trust and also through the court of basically of Carl Adams signing all his title rights and interests away. You know.
So I just want to clear up the last exhibit you referred to. You said it shows tax payments.
Well, it shows the record that was recorded in the registry of deeds of the tax payments and why it was a tax sale.
And
and the tax sale became the redemption because.
Can you show me what document that is?
Yeah, understandable. Yeah.
And that is.
It's 42, page 42.
Our page number is all different from your page number.
Yeah. And you read the dates. The tax collector, if you read the whole law, cannot release the documents or any deeds without the payment being made. And then the last payment was made was on September 26th, and the deed was recorded on September 27th, 1892. So,
when you say that's page 42,
yes.
where on the page is the number 42? I don't see anything.
It's on the bottom.
Handwritten?
No, it should be typed. It should be.
Okay.
It's the same appendix you've been showing us throughout.
I apologize for that. It might have been my error. But you can see all the documents shown that I posted on this, and it's very clear where everything came from. And I can give this to the court if it so desires.
If it's not in, I think we need to go on what's in the record before us.
Yeah, but if,
Okay. All right. Well, thank you, Mr. Clark. I think we understand your argument, and we'll hear from the other side.
Good morning, Your Honor. I'm going to take about 2 minutes out of the 15 minutes. I'm going to be about the briefest that can possibly be today. This is just real simple. Mr. Clark's claim is that ownership of the property comes from two sources, one through an adverse possession claim that's still alive, and the second through this deed from Thatcher Hallett, which he claims ownership. The land court has already ruled, and based upon the statute, that it's 30 days. The cases that are provided say you can't change the plain language of the statute. It wasn't done on 30 days under either a number of theories, either when the auction was held or when the deed was delivered. Either way, they missed the 30 days. So I'm not sure if there's any other argument besides that.
What do you say to your opposing counsel's argument that what happened in August of 1892 was not a tax sale, it was a redemption.
Well, first of all, he could have brought that up to the land court. I mean, this was, that was never, it wasn't part of his case. His case was his deed originated out of this tax title. And so all this I'm hearing, it wasn't really part of the original order, and Judge Foster's ruling is pretty clear. There was a title exam that looked at this thing, that followed the deeds right back from the source deed all the way through, and it just traced the record owners based upon the public record. And the public record says that a tax sale was held, and there was the Thatcher Hallett was the purchaser. He just didn't record the deed in time. That's really all there is to it. I mean, this other stuff he's talking about here was never part of the land court record or anything.
So it was recorded just late, a month late, or?
Yeah, but the statute is clear. It's 30 days. And prior to, I think, 1915, there's a law, the Act of 1880 or something that said that if you have a tax title, you have to record that deed within 30 days. It's right in the Act. Judge Foster cites it in his memorandum and order. So if you read the order of Judge Foster, it sort of set through the chain of title and how it all came to be.
The information about Matthew Hallett and his inventory, was all of that before Judge Foster?
Well, it may have been, but it's obviously it's difficult to follow, so but I'm not sure exactly how much of that all came through, but at the end of the day, if he didn't bring it through, he should have brought it in, and if he did, it really wasn't part of the chain of title. Again, trying to keep this thing simple. There's a chain of title, and there's a source deed, and it comes to a tax title deed. That's really where our case arrived at, and either the court heard what he said, it kind of didn't take it into consideration, or it just wasn't relevant. But again, I'm trying to keep my thing very simple, that the court's order was accurate.
Just sort of to situate us, which heirs are you representing?
Which heirs do I have? I represent the defendant in this case, which is Jeffrey Johnson, trustee of Old HYANNIS Road Realty Trust, which has an agreement to purchase.
Is he an heir? Or is the trust
no,
an heir?
No.
Are they abutters or something?
No, they're just purchasers. They have an agreement with certain heirs to purchase it.
Oh, okay.
Okay.
But they haven't purchased it yet?
No,
until
we're
this
trying to
gets
clear.
cleared up?
Well, we've got to clear the two issues. One, hopefully, has been resolved, and the adverse possession claim would go in front of the judge.
And so then, the heirs who rested on their brief, are they the purported sellers to your clients?
Yeah, there's going
Okay.
to be a distribution. There might be a petition and partition. There's all kinds of Hallets floating around. Because when that deed was defective to Thatcher, it opened up a whole group of other folks that have an interest in it also. But his interest, he's trying to claim his interest to his grandfather, which is Thatcher, which is apparently there's obviously more people now because by the tax sale being invalidated, it's got a whole bunch of other Hallets and all their descendants that are part of it now.
But so since 1892, have people been operating under the assumption that Thatcher bought it at the auction?
Most likely, yes. I mean, I don't know the whole history of it, but he may know more than I do. But we had a title examiner look at it, and then the court ordered one, and this is what turned up, is that the tax title was defective. Tax sale was defective.
Okay.
Okay, thank you, Ron.
Thank you both. The case is submitted. We'll get a decision as soon as we can. And that will conclude our session for today. I want to thank the court officers, thank the clerk, right over there, and we'll be in recess.